would you say, does law have a role to do with debt? And if so, what? Just throwing it openly. Debt is about money. What does law have to do with that? We're looking at laws and institutions at various levels. At community-based level, at national level, potentially for us as Africans, at regional level, the REC level, at continental level, and at international level. And we're looking at the laws and the institutions they create at all these levels. So one of the things I think that was brought out, I think it was by Isaac, was that laws bring predictability, or could bring predictability. And I just wanted to ask a question. To us as African, an individual African looking at it, whether you're part of the system or now you're out of the system looking at the system, is IMF predictable?
Yes.
Yeah.
Yeah.
Yes,
They are very predictable.
How would you say
yes.
that?
They extract, like,
Yeah.
they're predatory, they're extractive. They are geared to extract from the South, protect global North interests over and over again, guised as, they're coming to help, but really.
They are predictable in the sense that you're always going to get three things with them.
Mambo ni matatu.
They are austerity, privatization, and higher taxes. I mean, those are the key tenets that come with any IMF program. It is as predictable as the sun rising in the east and setting in the west. Yeah.
Yes, can you see that?
So for me, they are unpredictable in that when we did training for fair financing with Oxfam Netherlands, is that most of these international financing institutions, including the IMF and World Bank, they actually have a whole elaborate human rights section where they have signed and ratified most of the things we cry about. We just don't know, so we don't hold them accountable to that. So they are unpredictable for me in that they've gone and secured themselves and signed these agreements of observing human rights, sustainable development, but they violate them all the time. So they are unpredictable for me in that sense because they speak with a forked tongue all the time.
Okay. Yes, Stefan.
I think I'm going to go back to the point that I previously articulated, probably not too clearly. I had a long night, so. But they are very predictable because they have constantly used and enforced a definition on who is a debtor and who is a creditor, which is purely related to contractual solvency. Now, forget for a moment the case I've made before, private sector. But between two governments from the north and south, the definition on who owes to whom, it's a much broader and political definition, particularly on so many dimensions, colonial, ecological reparations, and much more. But what the IMF has constantly done has decided to forget about all of these and narrowly only look at debt from the purely contractual solvency angle. So in that, they have been very extremely predictable and extremely coherent in their own nonsense, because they've always brought it back purely to that contractual definition and not to the political reality of debt and how it originated.
I think for me, two other elements about IMF, speaking as a non-economist, non-accountant, and somebody who has aversion to figures, at least figures of the written kind. In a country like mine, or one of my countries, Kenya, you see this cycle where they keep on telling you your economy is doing well, you can borrow more, your economy is doing well, you can borrow more, your economy is doing well, you can borrow more, and then one day they just go, oops, You borrowed too much, you're in shit now, we've got to help you. And I'm like, but didn't you lie to me, the person, the citizen? When I was seeing your missions, you come there, you hang out with my president or whoever, you take those photos on the steps of State House, you release his press releases. Then it's like you're hooking me, and then like a fish, and I'm a fisherman, once completely I've grabbed the bait, and your hook is deep inside me, you're like, now I'll gut you out and there's nothing you can do. And I'm like, how do you get away with doing that? You know? And then also, again, for an institution that on the one hand keeps an appearance of being very transparent and of disclosing a lot of information, they also play me, the citizen, on the one hand by bombarding me with so much information per se and so much jargon and so on, that in the end I really don't know what's going on. So you can't really call it transparent anymore. You have to be an expert of a certain kind to be able to navigate, you know, all that so-called information. But on the other hand, also, while they come and they're imposing the conditionalities on my government, they put in conditionalities like that, like fight corruption, like good governance, like transparency, and so on. And some of that I'm told. But there's also a way in which some of the conversations it's having with my government, especially now when it's instructing my government what to do, isn't so apparent. Isn't so apparent. And the way they've engaged my government is so that even my government feels that is confidential information that it doesn't share with me, the citizen. And there's a complicity there because the IMF know what they're doing, the government knows what they're doing, they know that we don't know, and it's kind of okay. So on the one hand, you've given me a facade of being accountable, of being transparent, not accountable, but being transparent in terms of making sure I have all the information. But you also have a system where there are things you discuss with my government that we never get told, you know, and so on. So I find it, like the term that you used, forked tongue, I thought was very, very interesting, you know. Then again, when you talked about, again, Isaac, about predictability and enforceability, a number of people talked about that. In law, we have something called the Vienna Convention on the Law of Treaties. It was written in 1969. It was basically a codification of how international agreements should be done. And one of the terms of the Vienna Convention of the Law of Treaties that we use a lot, especially as human rights lawyers, and it works for us some of the time, is that a state party cannot invoke provisions of national law to defeat an international obligation that it has accepted. It's part of the core of the system, that when sovereigns negotiate, they negotiate from a position of equality. Myth. And that once you've signed on the dotted line, you've signed. And you've got to implement it. And it works very well for us, especially in human rights law. Because the government messes up somebody, we take you either to the High Court in the country, or the SADC Tribunal, ECOWAS Court, ESCJ, or African Court, and we quote and say the African Charter on Human and People's Rights says right to health, or the International Convention says. Then the government comes and says, I've got restrictions. Then we're very quick to say, Vienna Convention, you cannot run away from your international obligations, you know, and saying, your parliament, blah, 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 you must implement. That your constitution doesn't provide for this right. No, you signed, you must amend your constitution. And there it works well for us. But now when we come to this realm, my government, and it's a competent authority within government to negotiate and sign treaties, signed a debt treaty without asking me. Or sign some legal obligation, because not all of them start as debt. Some of them, they start like you are buying something. You're buying a plane. You know, you're buying some factory equipment. So the state is buying, then they can't pay, then it becomes debt. So it started as a purchase rather than really a loan, you know. So then you do this without consulting me, and then I'm stuck, and I can't run away from it. So that is one of the ironies that sometimes I find when you talk about the importance of predictability in law. I thought you wanted to say something.
Yes, I wanted you to just repeat the line you started with, because I want to lock it into my head.
Okay.
The way you had said it.
Yeah.
In terms of
That once a
country law cannot be used.
once a state has entered into an international legal obligation, it cannot use the provisions of national law to run away from implementing that legal obligation. So other states will be like, I don't care about the niceties of your law down there. That's your problem with your people. Me, you came and told me this, and this is what I signed with you, so it must be implemented. You know. So for instance, and the level of sophistication is what varies. But at least for all the states represented in this room, I don't know about Italy, but I know at least about a little bit about Canada, incurring sovereign debt requires some level of parliamentary authorization and parliamentary supervision. You know? And a lot of us, because a lot of us, former colonies of Britain, which even South Africa was at some point in time, but everybody else, Kenya, Zim, Uganda, Tanzania, Malawi, and so on, we had a cookie-cutter constitution. The constitution was built from the same template. So some modifications were made here and there, but it was largely the same. So there were provisions already for parliamentary oversight. And there were even acts of parliament around loans and around debts that were already passed by the colonial parliament before we took independence. It was in our list of laws. So we've added more, but it was there already, you know. So all of these countries already had laws that provided for parliamentary supervision or authorization. But the government went and incurred legal obligations without following the procedure. So in principle, at the national level, these people are right in saying we will not honor obligations that didn't follow the proper process. In some of them, we don't even know where the money went. Our guys fly abroad, take a Eurobond. That Eurobond money never even round trips through our country. You wish at least it came and passed by and then you could smell it. You couldn't touch it. You couldn't eat it, but you could smell it. But half the time, they incurred it there. They put it in an account there. Then they moved into their personal accounts there. So it never, ever entered our legal system, even for a day. But now we have to pay for it. And what they've done is illegal in terms of our law, but that doesn't stop us from having to pay, because it was signed at the international level. You know. And again, when you're talking about predictability, and Stefano tried to reach it out, a lot of the time we start by thinking of loans or debts from multilateral financial institutions, IMF, World Bank, blah, 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 and so on, because the UNDP and types are mostly grants when they do give. So we think of loans from entities like that. Then we also think of bilateral loans, government to government, which largely has been, from the global north for most of our existence. Then with the look east policy of certain states in the last 20 years, at least now has been east, But we think of states. And many times we forget to put in our universe when we're discussing these things, private debt. When you go get a loan from a bank. Or even go get a loan from a rich person, because that also happens. People who loan states.
Purchases, PPPs.
Yeah. Or the PPPs, the public-private partnerships, where then a legal obligation and a debt has been incurred because you asked some private player or para-private, because some of them are state-owned enterprises, like these Chinese ones. They're state-owned enterprise to build for you a road and then do build over it transfer after recovering its money, or build for you special gauge railway, blah, blah, blah. And one element that's also forgotten there is that sometimes the original person that you negotiated with, who at least might have some shame when you default and you go to talk to them, it's like when you take a loan from a friend. Yeah, you should pay, you can't pay. But this friend, because you guys have history, your family, your friends, there's a limit to which they will shake you down. Yeah. But now this person can sell that debt to a third party, who can even sell it to a fourth or a fifth party. So the person who's now coming to demand legally owns the debt, but they're not the person you started out with.
Yes.
So we enter now into the field of what we call vulture funds.
Debt collectors.
Yeah. And people who come and they'll remorselessly attach any asset, because for them when they're buying it, they buy it probably at a discounted rate, a hugely discounted rate. But then now they come to claim for the full amount with costs and interest and penalties and so on. So there's other whole range of players in this debt thing that nobody negotiated with called vulture funds. In the context
Does that
of
happen for the state too?
Yes.
At state level? 'Cause
It
I
happens a
think
lot
at
for the state.
personal level it does.
Even for the states.
Yeah.
Wow.
It does a lot
Even for the
them.
states. Like for instance, I'll give you an example, and this particular one that I know comes from Zambia, but all our states have it. During the period of the Cold War, a lot of African states took loans from Eastern Europe. Government-to-government loans from Eastern European states, Romania, Czechoslovakia, blah, blah, blah. And a lot of these were actually taken on friendly terms. We were fraternal with each other. And then we couldn't pay. And in many instances, the government in question, in his mind, has really written off that debt. They're like, yeah, I know you can't pay, but we're kind of buddies. We vote together sometimes. We're in G77 together, so it's kind of like, okay. Then you find this rich American businessman who then went and bought off these debts. And they bought it off at a son, because the person said, yeah, Romania lent Zambia maybe $50 million. And in principle, it was supposed to be paid with an interest rate of 3%. And they loaned this maybe like in 1979. So at some point, they were like, you know what? Frankly speaking, even in our books of accounts, we have written this loan off. So this guy comes to buy this $50 million loan because he's saying, you guys, you're never going to recover this. Let me give you $5 million. You transfer the thing to me. I walk around with it. So Romanians, oh, I can make some cash off it. Cool. So they sell it off. And then this person comes and says, under the terms of the contract, 50 million plus 5% interest compounded over the last 20 years, now is $200 million pay. And then now they go get a judgment from a court, and the court will give them a judgment because the thing was legally assigned to them. And then now they look for any of your assets, especially abroad. An asset that's not caught by the principle of diplomatic immunity. You know, so your government maybe owns a building in New York, but it hadn't yet registered it as. Or your plane lands in some third state, you know, and so on. So there's quite a bit of that as well. Yeah. Okay, now that we said that base, let's do one more thing. I'd say now we know that now some law is involved in this debt thing. So again, I'd like to throw it back to you. Just name any law in your country or that you know of that you think should be involved, should be put on the table when we're discussing debt. Just any. Okay, Crystal has started with one, the PPP Act. PPP Act, yeah, that's one. Any other that comes to your mind? Yeah? Don't stop yourself. The Appropriations Act, yes, very much so. Appropriations, yes.
Yeah, you can go first.
Go fast, yeah.
Access to information.
Very good. ATI Act, yes.
Okay, I was going to raise the same one for us.
Any other? Yes, Isaac?
Public Finance Management Act.
PFM Act.
Constitution.
Yes, Constitution. John?
The IMF Act.
IMF Act for the countries that have it.
IMF has an act. Okay.
Yes, any other?
The articles.
Don,
Yeah.
I don't know the exact laws, but I know they are there. It's called Chapter 4 in our Constitution. All those laws that have to do with human rights.
Yes.
Because I think debts have a direct bearing on human rights. People can't access health, it's a human rights issue. They can't access education, it's a human rights issue. So I don't have the specific law, but
Do they all fall under the Constitution?
yes.
In the South African
Chapter
Constitution,
4
yes.
In our Constitution.
In the Zambian one, it's what? Chapter 9? No, chapter 1. What is Linda Kasonde's foundation called?
Chapter 1.
Yeah, so it's chapter 1 of the Constitution in Zambia, chapter 4 of the Constitution in Uganda, chapter 9 of the Constitution in it. As we call them what? The word I just called.
Bill of Rights.
Bill of Rights. In Zim, we call it the Bill of Rights.
Yeah.
And isn't the Bill of Rights as well?
Yeah, but there's a word, it's just not coming to my tongue now. The chapter in the Constitution where a lot of them are established. The Human Rights and Equality, the Ombudsman, the Commission for Administrative Justice, and so on. Yes, so sometimes you might forget that these are important institutions to be discussing in this context. The National Human Rights Institution, the National Anti-Corruption Commission, the Auditor General, the Controller of Budget in countries where it's separated, those kinds, the laws establishing them. Any other that you can think of? Yeah.
Well, it's not a
Yes,
law,
okay.
but should we be considering the last state of the nation and the budget vote before we borrow? Because that should tell us if we can pay or cannot pay. Though they are not laws. But I mean, at least citizens have access to that. We can all listen to the state of the nation and make the points you want to make. You can listen to the budget. Because that already tells you where you are economically. To can borrow or not borrow.
Yeah. So again, usually it's very good to highlight that and ring fence it. The junctures at which those that govern us get to explain to us what's going on in our countries. So in some countries, by law, by the constitution, the head of state or the head of government has to deliver, you know, a national state of the nation address to parliament, or in our case, to both houses of parliament. That's one. Then the annual budget statement or the budget making process, which implicates many times the finance minister. The finance minister has to go and be accountable to parliament. So those as junctures. So I agree. Any other? Yes, FG, and then we'll come to you. And then.
Is there any answer of creating independent parliamentary offices?
Yes.
Reporting directly to Parliament without any undue political interference, or an independent auditor that
Yes.
is auditing the books of the government, because these are very important to see how the resources have been allocated.
Yes. Agreed. Yes, you next.
In Kenya, we had the public debt management bill. I don't know if it's under the Finance Act or not, but it's also one of those legal things to look at.
Yes. Actually, in Southern Africa, just so you know, in Southern Africa, what they did is a SADC Parliamentary Forum went through, with the help of TJNA and other organizations, went through a very elaborate process of arriving at a model law on public finance management, a PFM Act, which then it's using to market in the SADC states to try and tell them to upgrade their laws. And from what I learned today morning in my group, my other country, the Zambians actually recently passed, it was not necessarily directly driven by this model law, but they passed a relatively elaborate Public Finance Management Act for themselves. There's still some gaps, but they tried to pass an elaborate law. Any other law you can think of, just off the top of your head? Would you include the Environment Act?
Yeah,
Yes.
Yeah.
Yes.
yeah.
Definitely.
Yeah. So anyway, it shows, you know, the way, I would say it shows the way public management of public affairs generally, and debt as a subset of that, interacts and interfaces with the law at various, many ways, more ways than sometimes one would think. Yes, Stefano?
I think we mentioned very many pivotal pieces of legislation in our respective countries. The problem is that when we're talking about debt, and we're talking about, therefore, an international contract, what has happened is that the hierarchy between contracts have somehow assigned automatically primacy to the contracting provisions within either financial market or the international market vis-a-vis whatever piece of important legislation we have in our respective constitutions and national provisions. This is somehow what has generated a primacy of the private nature of that contract vis-a-vis the public interest, according to which, in theory, the sovereign borrower have actually incurred for the loan for. And this is somehow not even questioned.
Yeah.
You know, it's just given as a matter of fact. You know? And I wonder whether this actually should be, sometimes in our politics, the fundamental entry point of our analysis and our counteraction.
Yeah. I mean, it reminds me, and you'll speak next, Chris, reminds me of the point that Nombuso was so, I wouldn't even use the word dramatically, but so graphically brought out to us. Because it's an issue of that thing of culture. Who sets this prioritization? And it is sold to us in a way that looks like it's unchangeable. It's
Yes.
immutable. That's how things are. Must they? So that's a question Stefano is asking. This thing is not working for us. Are you saying we are all stuck with it? You know.
Yeah.
I'll talk about that later, but yes.
A few years ago I did a paper on a PPP project in Kenya in the medical space, and the contract didn't go through Parliament and was negotiated through a private law firm that had affiliations to the World Bank. They had all these, awards from the World Bank and analysis. They were Kenyan. And so I remember speaking to you, and you might not remember this, but you gave us a quote that said, there's a disturbing trend towards law firms enabling economic transactions devoid of any consideration for human rights, turning them into mindless mechanics of the law rather than conscientious engineers of a just social order. So when I, leading from Stefano, or, moving on from Stefano, when they're negotiated privately, and it's like business entities, multinationals, outside of public interest, outside of an accountability and transparency framing within Parliament. Parliament themselves didn't even know what was in the contract, yet it was negotiated, by private law firms within that country. And even with a PPP Act, it still does what it will. So I don't know how, I don't know where it sits, because it seems like we have these sovereign frames of legislation, but with a private finance entering, it's like, it doesn't really matter.
Yeah. Yeah, I remember how excited you were with that quote, and now you're like, Don, I've published you. You man who doesn't write, But it's something I constantly, then and even now, keep on telling lawyers. And of course it applies to other professions and disciplines as well. How do you situate yourself within your profession? Or as now Jason has given us very good words, or Aphrodite has given us very good words over the last 15 months. Are you a rule maker or are you a rule taker? It was the same thing. This system, are you amongst those who are designing it and reforming it? Or are you amongst the sheep who are just mindlessly implementing it? That's why I said, like a car. Are you an engineer that's designing the car? Or are you a mechanic that just tinkers at the edges to work with what you found? And so on. So ask yourself where you sit. But again, that's one of the ironies also within our countries. And I see it in banking and finance, and I see it also in the legal profession. Within our own culture, as you told us. And this, I think, is even more, at least in my context, the way I see it, it's a perception issue, is a post-independence issue rather than a pre-independence issue. When you go to Kenya now, or to Tanzania, when you go to Dar, the most respected lawyers are the corporate lawyers now. And I'm telling you, before independence, it wasn't this way. There are countries that you still find where to be a constitutional lawyer or to be a human rights lawyer is the most respected. And everybody's like, looks at you with awe. But if you look at most of our countries now, the guys that do the big deals, which means they mostly represent the multinationals, regard themselves as a class above the rest. They live in their own rarefied bubble. And they hobnob with other people who have money like them. And in our countries, they consider even doing things like running for bar leadership to be beneath them. Small lawyers with small cattle and goat law firms, you can do things like aspire to be, president of Tanganyika Law Society, Zanzibar Law Society of Kenya, So they've put this hierarchy. And the most interesting thing for me is not even that, is that when you look at the subconscious of the average lawyer, they've actually accepted this. So it's not really spoken about, but it's almost like, that's a club of the funky lawyers, and then there's the rest of us down here. So sometimes it comes with some awe, sometimes it comes with some resentment. About half of you might start your own small practice in the corner. They are doing matrimonial, criminal, these small people with their small problems and their small money. Those are the ones who can get. But all you're dreaming is, when I get a corporate client, and so on. So what makes us accept this hierarchy, even amongst ourselves? Can you see them?
I think it's a culture at the universities, and it ties with money, because he who pays for it owns it. because I speak a lot in South Africa as a public speaker, and whenever I get an opportunity to speak to a graduation party of someone getting a BA or in accounting or economics or whatever, I always ask them, who do you want to work for? What's your ideal? And for sure, it's always between Ernst & Young, PricewaterhouseCoopers, the big five.
Yes.
You know, and then we say why, and they say, well, that's where the experience and the money is, and you know, those people pay well, they set you up in your career, and I'm just like, but it's the very people that are killing us.
Yeah.
So I think it's a culture, but it's a culture that the validators, in the way we used before, know, and they push it through many things. I mean, it's interesting for me that they will pay millions of rands for a 1-minute advert. You know they do that?
Yeah.
1 minute. But they know the more it's repeated, the more it locks into your psyche.
Yeah.
So you see,
And it makes you
Deloitte
accept.
and Touch,
Yeah.
and they show a person with a suit, and there's water, and there's the most expensive whiskey and a car, and you're just like, this is where I want to be.
Yeah. And you know, there'll be Stefano and then Job next. But to just build on that, you know, the big law firms and the big 5 accounting firms have rewritten for themselves, not for other people. They have rewritten for themselves the rules around conflict of interest. We're talking about predictability, we're talking about dignity, ethics, and so on. So conflict of interest used to be known. Over the years, for many institutions were smaller. You could only represent one side in a thing. But you find these really huge mega law firms and the big 5 actually engage in conflict of interest. If any of us running smaller shows did what they did, they wouldn't get away with it. So you'll find Ernst & Young represents and advises my government. But at the same time, Ernst & Young represents and advises OECD.
Yeah.
But at the same time, Ernst & Young represents and advises Barrick Gold and audits Barrick Gold. You know? So then they come up with their vision of the world, which they influence my government to pass as law, which then benefits their clients, which then means the clients make more money and they make more money. So they're on all sides of a thing. When the rest of us should be told, pick a side.
Yeah.
You know? That's why, again, you can find a big law firm. In one case, it's actually representing the government and maybe even helping it change law in one instance or one file. But at the same time, this same law firm is representing a mining consortium that's suing the government. You know, and so on. And then they try to say, no, we're big, you know, we've got Chinese windows, we've got different departments, we sorted it out. These 2 departments don't interact. I'm like, yeah, really? You want me to believe that? You know? Anyway, Stefano, then Job.
Sure.
I'll book a place later. I'll tell a joke at the end of it.
All right. Okay, Job?
Yeah, when Stefano was speaking, I was just trying to ask myself, okay, in our own spirit of incrementalism, we are calling for legislation in the UK and New York, but we're also calling for disaster clauses in debt contracts. I was asking myself, you know, why the UK, why, you know, from just that conversation that Stefan was having in relation to the discussion we're having about the national laws. Just we can have some reflection.
Yeah.
We
Yeah.
know that, you know, most of the debt contracts are procured using those laws. That's why we want, like, legislation in those specific jurisdictions. But why should that be the case?
Yeah. Yeah, I'll make a point on that later.
Yes.
I would say one thing, and then I'll hand over to Ranga for a while, so we do a duty and then come back. For me, the lesson that comes out of the session we've co-created, or the discussion we've had up till now, is the need for a mapping from a law lens, or a lawmaker's lens, of all the laws that intersect with the issue of debt. I always remind myself and advise myself that the fact that I don't know about it does not mean it's not happening. So we know we have colleagues like the African Sovereign Debt Justice Network, Afronomics Law, who have done a lot of work around this. I haven't asked them this particular point, that country by country, would you say there's been a proper audit or mapping that gives people an idea of the laws and the institutions that at a country level they should be looking at in terms of when they're deepening their discourse around debt? But it's clear that for us as a group, at least, that's something that's needed. And of course, we won't reinvent the wheel. You want to take us away?
Yeah. Okay, thanks, Don. So far, we have discussed the role of the law in issues of debt, and also the various acts or laws that touch on debt, like this one. But another caveat is also regional laws. For example, at the REX level, we also have laws that harmonize all the national laws at the regional level. So we are seeing that debt is increasing, and now it has reached to about 1.8 trillion. Like, this is the total amount of debt for the whole continent, and this has increased by 183%. And in terms of debt composition, we are seeing that in the past, most of the loans that were being contracted by our governments, they were owed to official creditors and multilateral lenders. But now we are seeing a shift towards private lending, and mostly these are commercial loans, which are expensive. So because of this debt problem, our PALUS annual conference for this year, it touched on this issue of debt. So we have a lot of actors, that are involved in this issue of debt, and we have identified lawyers as one of those critical actors, because when you talk of debt, it's something that is contractual. It means contracts have to be drafted, and who draft those contracts, and what are the clauses of the clauses in those contracts. So tying this to the issue of slavery that we mentioned earlier in the morning. So when slave trade was happening, there were also Africans who were working with the slave traders, supporting them in different ways. So we said that slavery still exists this day and is existing in a different form. So we agreed that debt is part of today's slavery. So we have professionals who are also working with these slave traders. And these professionals, one of them are the
enablers.
Yes, the enablers. Yeah. So the conversation that we are having now is to say lawyers, they play a central role in these issues of debt. Like what Don mentioned, that most of these lawyers, they prefer, to work in these commercial things. They're making a lot of money. But one thing we need to remind each other is that lawyers are also part of the society. So whatever that affects the society, they are also affected. And lawyers, they command, a lot of respect. They know, they have big networks. So we are trying to appeal to lawyers to say, okay, as much as you want to make money, you're also part of the citizens, and you have to contribute to the development of the continent. And how do you develop that? You use your influence. For example, when you are talking about contracts, okay, what kind of contracts are they going to draft, and what are going to be the implications of those contracts on socio-economic development? The type of contracts that our governments are signing, they are tilted towards the creditors. And I think Don is going to touch on the various clauses, that makes the contract that we are signing not to work for Africans. And it also brings the question on whether we should have a model contract that can be used by all the African countries when they are negotiating for loans. We are saying Africa, the rule maker, not the rule taker. And when you want to make rules and not be rule takers, we need to be speaking with one voice. So the idea of coming up with a model loan contract could be one of those things to say, okay, as Africa, we are speaking with one voice. When we are contracting loans, these are the terms and the conditions. So we all agree that there are some problems, when it comes to issues of debt. And partly, some of these problems are a result of the law. Like, our laws are weak, and we need to make sure that we strengthen them so that we are in a position to manage prudently our dates. We also talked about the global architecture. There are rules that create this architecture at the international level. So we are saying we need to also use the law to dismantle this global architecture so that whatever agreements, whatever we are entering into, it will, have a lot of benefits to the African continent. Yeah, I think I'll ask Don to continue the conversation.
Okay. And again, yes, Kanyisili?
So I think from what Rangas just said and where you ended off, and in light with the investor-state dispute settlement center, whatever, can there be a law that protects states against debt? And I'll tell you why I'm asking, and I'm sure I'll shock most of you. But I have debt at personal level that I have no intention to pay. And the ANC, at least fuck up as they are, at least on that score they did well, that no company can take you to court if you can't pay because you're unemployed. And since I work for myself and I don't have full employment, I can evade it. But they also can't attach anything from my house because it is on, I don't agree with the name, but tribal land. So that's why I moved away from the city. And I went and built on, we call it Mhlaba Wamakosi for us, land that belongs to the king, the chief, the clan, because it's not land that is sellable. Even as you go and live there, I mean, I bought like a whole plot for 800 rands at the time. So it's not really buying, they are just saying thank you to that person, so they can't attach. So they sold my debt to private collectors. That's why I was shocked that they do that at state level. Then I get a call and I see the number is 031, that's Devin, and I'm like, hello, and they say, your net bank debt, and I say, but who are you? The private client, I say, oh, okay, you are talking to a person, a very rebellious slave, I know the law. I have no contract with you, I have a debt with NetBank, who knows very well I can't pay. You've gone and bought the debt, that's your problem. Not my problem. So, what protects states, I'm trying to say, I'm giving this example so you can see, at individual level, the state can protect you if they want, but what protects them?
Yeah. I'll comment on that. And Asaba making, when you're asking, is there a law for, and you're describing the basis on which there's some protection under South African law. And I would say the most important laws are actually values laws. Laws that set out our values, like many times the Constitution. In the Constitution, you'll have the Bill of Rights, blah, blah, blah. So it's basic, and a lot of them, they don't go into the details. Details will come elsewhere. But in the hierarchy of laws, those are the most important, because when everything else fails, you're supposed to go back, like a good constitutional court does, and says, what did our founders intend? Life, liberty, equality, blah, blah, blah. How do we apply those big principles, lofty principles to this situation? And just like, sorry?
It's like what you do, because like the Kenyan PPP Act, if you go behind the scenes, aka go to bars and talk to the people involved, it was actually templated by the World Bank. So is there any also way in terms of protecting, like also protecting who templates our laws?
Yeah. And in fact, when we were discussing with our Zambian colleagues, that's one of the things that came out. They're giving an instance where the Public Finance Management Act, in some places talks of the Minister of Finance, then in other places talks of the Minister responsible for Finance. And they were wondering, what was that? So I was telling them, we'll read together, there'll be time, but in my view, it could be one or two things. A template approach, or mischief. It could be just some sort of incompetence. You took the law from Nicaragua, did a find and replace job, put Zambia and changed a few things, and then inherited things which might make sense in another person's language, in another person's legal and constitutional culture, but doesn't make sense in ours. So there's a lot of that. And laws that have been, enacted or reformed with IMF World Bank support across the range in several things, over the last 20 years, have that problem. Because they also have a limited pool of consultants that they like imposing upon you, and so on. So it could be the template thing. But some other times, you can find that actually the drafter very carefully knowing that I want to give a facade of transparency and checks and balances and institutional safeguards. But I want to leave vague enough language there where later my minister can wiggle around, and anytime we want to catch her or him, they're able to get out with sophistry. You know, Isaac?
Just throwing in an observation. This conversation is very interesting. I've seen a lot of conveners engaging, asking questions, but I just wanted to know if the other participants are equally finding it beneficial, or if the conversation is highly elevated, so that ultimately John and Ranga...
It's a conversation of the converted, kind of. Yeah. Yeah. Good point. Good point. You want to give feedback on that first? Just off the top of it, what you're feeling right now on the question he has asked. Anybody? Especially somebody whose voice we haven't had this afternoon.
Yeah. I shouldn't be the one who answers because I've been talking. But I mean, I appreciate the fact that you didn't come at it with legal terminology. Because we never read legal terminology at all. It comes in very small print, very technical, in anything, you know. So we don't know what legally it meant for whatever it is we are doing. Because it's small print, it's technical, but that's not how we've approached it.
Anybody else? How are you feeling about where we are at right now? Yes? The lady at the back, then please.
Thank you. I think it's, my name is Matrina from Zambia. Yes. I think it's a very beneficial conversation because we are talking about things that we interact with in our lines of work. So I'm a public finance management researcher, and in my line of work I do studies, policy brief that set on the things that you're talking about, and one of the things that we struggle maybe to interpret is the legal framework. So this conversation really helps us to at least have a picture of the details of what we talk about, and also link the issues around it.
Okay. Cool. Yes, PJ?
Just to proceed from what she has said, we are actually following up on the discussion, and it's the fact that we are able now to connect whatever we have seen into the law, into practice. Yes, so it's cutting across what we understand.
Please ask him as many questions as you can. Some of us have got a lot of access to him, so in an event that there's something that you are listening, doing it.
Okay, cool. And thank you for that. Thank you for that. A barometer check is good.
I don't know if you gave me a straight answer. Is there a law that can protect states? And if it's
Yes.
not there, should we be campaigning for that law?
Yes, yes. I was going to come to that. But yes, Stefan.
I want to speak to this if possible. So, I'll give you three answers. The first one is that at the moment, as much as the way the economy has been organized has transitioned to the global, to one global economy, it has also rejected global normative frameworks, clear global normative frameworks. Now, in that space, the state remains sovereign. If it doesn't want to pay, it doesn't pay. If it doesn't want to honor a contract, it doesn't honor that contract. That sovereignty remains fundamental. And very often, we just either bypass it or think that it doesn't exist anymore. Now, it doesn't mean that there are no consequences in the way in which the global economy works of a gesture of that type, you know? But that sovereignty remains, you know, and I think it is very important. Secondly, it is time, particularly on debt, and I think we'll discuss in the next couple of days, to start thinking what kind of global normative framework is required to make sure that the public interest remains central and not secondary to the debt contracting. And third and last, in doing so, I don't think we should think that other jurisdictions, for instance, even the New York and DC question that, and London question that Joe was asking. You know, there's a little bit of discussion of saying if a lot of private debt is transacted in those spaces, if only legislation in those places can be improved, they'll be better off. I think we go back to the rule taker, you know, expecting that those legislations would be drawn in our interest I think we have a whole history behind, right? To know that that will never happen. And even if it does, it's not a solution, because once again, we sit on a rule-taking position rather than a rule-making position. You know, so that's the reason why I'm not looking very favorably with those particular initiatives, because they remain stuck within national legislation. We really need a global normative framework. And until we have it, the state remains sovereign. We can decide what to honor and what not to honor.
Thanks, Stefano.
Thanks.
Yeah, and I really want to build on that, because I think he's answered it, especially starting from the point of, let's start first with the values. What are the important values? Then we drill down. So I already said one thing, that the most important laws are values laws. The second thing I was going to say before I explain is that the solution is not always more law. Sometimes the solution, on all things in life, sometimes the solution is more elaborate law, but it's not always. Because you can also get tied down, and people like the Kenyans will tell you, you can get tied down when you've invested 10 years of your life writing very elaborate laws on everything down to the detail. And you realize that these laws are not helping you. So the problem wasn't more law, you know? And like I said, with most of our constitutions, we started with the principles and the values already written in the constitution. And there was probably some statutory framework, some acts of parliament to implement it. So had we robustly implemented this, we would not necessarily have needed more robust laws. So sometimes the more robust laws just says there's nothing wrong with having more elaborate rules so that the procedures are clear and the safeguards are built in. But sometimes you can find you're just being taken in a merry-go-round, while the core thing that you should have addressed remains addressed. Like, for instance, the ethics of the people in office. And more importantly, what you're going to do about it, you know. So yeah, on what you said, actually most nations started out, or most states started out with principles, and FG, you can build on this, usury, started out with principles around protecting especially the vulnerable economically. So many countries, for instance, have usury laws. These are laws that saying that if a citizen is going to need a money lender, the money lender cannot exploit the citizen beyond some certain level. And if they did, the law will not back the money lender. The law will not be used for the money lender to get his money back. Because they would look and say, but that's an odious contract. There's no way that was fair. You know, most laws started out that way. And again, in most countries, and the US is a pretty good example, even though I can't now articulate the details, insolvency law is actually mostly around protecting the vulnerable creditor. You took a loan, or you went into business, you took some goods, blah, 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 and for some reason you can't pay. Okay, we get that. So we create a system whereby we ring fence this debt that you can't pay, and we see what to do with it. Sometimes even it may mean taking away your company and putting it under receiver or blah, 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 or something. But the main aim was protecting you so that you don't end up jailed or dead just because you couldn't pay a debt that you contracted mostly in good faith. So those were the key values. Now the question is, we're going to then ask ourselves, if those are the key values inside the state, which is a question that I think Stefano was asking, when we go outside the state into the national arena, have we transmuted these values enough? And if not, then what should we do? And again, in some instances, it does require more law, and it does require creating new institutions. So we should focus on that. But it's not in all instances. You know. So for instance, I'll show you one instance where it is not. These values that we're talking about, these principles such as usury, such as protecting a creditor and so on, if you use international human rights law as we know it, and we take a rights-based approach to interpreting this phenomenon and these things, then there's already enough protection there. So it's about how we implement it, rather than needing a new treaty. So for instance, the UN human rights system, under pressure a lot from activists in the global south and of the global south, for instance, has in the last 5 years then created within the human rights mechanism a UN expert on sovereign debt and human rights. And part of our work, the current expert is our sister, Professor Atia Waris, who's a professor of economic law in Nairobi. She's a current UN expert on debt and human rights. Part of what her work is to develop the thinking and to developing our understanding of existing norms, how we interface these two. So how should sovereign debt interact with human rights? How should human rights considerations be brought into this sovereign debt process? So in a sense, you can see that here, it's not necessarily that we needed per se a new treaty. It's about how we interpret and apply what we have. And I said, including in our context as activists, also disruption. Also disruption. Because when the system is made against you, is designed against you, but you have to use the same system as it exists to try and, call for your rights and call for the system to change, sometimes what you need to do is to be disruptive. So for us, even in our strategic litigation, on a whole range of issues, sometimes we file cases which we know we will lose in court, or we stand a high risk of losing in court, but it forces the necessary social discourse around the issue. It calls the necessary attention to the issue. And even in the process of losing, it helps generate the right anger amongst the citizenry till something has to give. So we may lose in court, but with this opprobrium, Parliament has to do something about it. Or something else has to be done about it. And that is where, like even the investor-state dispute settlement that you're talking about is one of the things that we should look for ways of going. Because the ISDS erected on a framework of per se transparency, accountability, good governance, public participation, and so on. The ISDS part then is a closed process. So when you go to ICSID, the International Court for the Settlement of Investment Disputes, you can't file an amicus brief. In fact, the entire process is confidential. The entire process, unless you find a way of getting information from your own country, or you find whistleblowers inside the system, we, the citizens, never get to know that our states have been sued. Yes. We never get to know when our states are going for the hearings. We even don't get to know who's representing our states. A lot of these are actually then tackled by arbitration rather than litigation, which means the arbitrator is under no obligation to explain in more detail how he or she arrived at their decision. So the only thing you get to know about the decision once it's been published and the amount you're supposed to pay. But we're talking about systems of public participation, we're talking about inclusion, we're talking about transparency, blah, blah, blah. So in some things, we just have to totally disrupt the system and say this system doesn't work for us at all, and so on. Yeah. But so in some instances, new institutions will be needed and new laws. And they could be at the national level, the regional level, the continental level. So again, one of the ways that we've seen law used in our region, in the Southern African region, for instance, now, is getting regional legislative bodies and regional deliberative bodies to pass model laws. So they study what is the experience of every country in the region, what's worked well, what's not worked well, what innovations have been put, blah, blah, blah. And they condense all of this into a model tool of best practices. And then they use it as a tool of now going to engage in the countries for reform. And of course, not everything will work for every country, but at least you have a tool that you can use if you mean well. And the regional bodies, remember, they're also for collectivizing our approach. So for instance, at the African Union, again, an aspect of law is not hard law, but one of the things the African Union has been very good in coming up with is common African positions. So on most issues that are important to us, like for instance, when we're going to do the SDGs, and before that, when we're going to do the MDGs, and even in principle, as we develop or improve or make more comprehensive the African position on climate action, we go and sit amongst ourselves and come up with a position. Many times then appoint from amongst ourselves a champion who then leads in pushing our position. So common African positions is also another way of laying out the law, because once the heads of state have passed it, because everything the heads of state say has some legal weight. Even if it's not a hard treaty, even if it's just a decision, the decision has presidential value. It means we should follow it. International law, implementing international law in good faith. So it does have legal weight. So in principle, an African state now going, if we had a common African position on debt, an African state going to negotiate with someone will say, you know what, I am bound by the laws of the UN. I'm also bound by the laws of the AU. The laws of the AU said this is what we should do. I do not want to be the weak link. Of course, the ideal and the real is something else, but that also depends on how we develop our capacity to oversight our leaders and to call people out. But also, there's a whole, and that's the thing we always try to remind people, there's a whole international financial architecture that was designed for the AU at the period of the move from the OAU to the AU, which would really have strengthened the African negotiating position, the African legal position, what we call Africa's financial architecture. The sad thing is many of the people who run our governments now, because they were not there at the time, and we don't have, in many of our states, good systems of handover of information, they've forgotten. So under the AU structure, right from the Constitutive Act, there was meant to be an African Monetary Fund, which was to be preceded by an African Monetary Institute. There was separately supposed to be an African Central Bank, which also had a process for how you got there. The other elements, we have, what is it called? Africa Risk Capacity, which exists right now, is established by statute, which is like a sovereign insurance, disaster insurance pool for African states. And the designer, they said, we know when a disaster happens, either a medical disaster like Ebola, like COVID, or so on, or a natural disaster like some earthquake, or whatever, you know, or even sometimes mud-bent disasters like the beginning of a war. We know the world will come to help you eventually. But many times the make or break are the things you do in the first 2 weeks. The immediate mitigation. Where can you get resources in cash and in kind for the immediate mitigation? You'll be able to save much more lives, save much more infrastructure, begin a turnaround, blah, blah, blah. We know the IMFs, the World Banks, the WHOs, the UNDPs will come eventually. Of course, we've also learned that if things are really thick, they'll run fast. Like when the guns went off in Khartoum, everybody and their mom first left. You guys, you're on your own. You know, then after running back and sitting comfortably in the home country, like, okay, maybe I feel a bit guilty over what I did. So can I call somebody there and see if I can send you some money so I can pretend that I'm still in the humanitarian action work? But yeah, so Africa Risk Capacity was set up precisely for our states to pool resources so that should anyone or any group of them need it, they can get it. Of course, the one body that forgot its existence or its raison d'etre was Africa Risk Capacity when COVID came. Another argument could be, is we were not designed for all 55 states to be in shit at the same time. You could make that argument. But at least we should have had your voice, you know, anyway. So, among the laws we should remind ourselves is that if we go back, because for each of these things, an AU treaty exists. And the general rule in the AU is once 15 of the 55 states have ratified, it comes into force. Of course, it binds only those 15, and then the rest can accede as they go along. Now, all these laws setting the international financial, African financial instruments architecture, all of them have 2, 3, 4 signatures, ratifications. None of them have achieved 15. Even when the states meet, we're the ones who try to remind me, this group, the STB group, we don't even know any other group right now that reminds them that, you know, you guys, if you had an African Central Bank, an African Statistical Office, and not a voluntary association, but established by law, which is mandatory, you'd then be able to collect certain information at the continental level. Then also you'd have a basis for making certain rules at the continental level, which need to be domesticated. And there may be challenges there, but at least you've got a starting space. And of course, colleagues who help Africa, they're very keen not to talk about these institutions for their own selfish interests. So you won't find GIZ, which is now all over the place, in the IFF space and even now in this debt space. You never find them talking about the African Central Bank or the African Monetary Fund as important things. You might hear them telling you OECD recommendations, but not. So part of the law we should remind ourselves is, yeah, here law is needed. And we can get more dramatic as we say, let's get disruptive. So we're beginning to co-create. Because in international treaty law, there are also things known as protest treaties. Sometimes you sign a treaty, not because you have intentions of implementing it, but you've got intention of sending a message, you know? So when we go forward, as we deepen our own understanding of these things and our responses, one of the things we could do is a protest treaty. Let me show you a recent one. Burkina, Niger, Mali, and so on, signed a treaty the other day saying, if any of these ECOWAS states comes at us, we will defend each other.
Yes.
If you look at the treaty, they haven't provided any modalities for how they will.
But they're passing a statement.
You know, but it's a major statement being made. And the statement has political effect, you know. So you can say that that is also a tool at our disposal when we think of the role of the law in the context of debt. And you think that law, if you remember, the law can be at community level, national level, regional level, continental, international. Yes, Jason?
Thanks, Don. I think just also for the benefit of all of us, I want maybe just to get your thoughts on how legal strategies can be used by groups like us here in the room to twist maybe lawmakers to change laws, but also twist other government institutions or agencies like the Office of the Auditor General or the judiciary, for that matter, to get more involved in issues of public finance. And a few cases come to mind. The most prominent one, of course, is the Mozambique tuna bond scandal, where it started very much at the community level. It was a small group of civil society organizations that came together and challenged two Credit Suisse loans that were issued to Mozambique. But to what extent do you think the law and those of us who are interested in how the law and debt intersect should be paying more attention to that? And I think it dovetails a little bit to what Honorable Kanisile and Don are asking at the national level. How do we create those protection mechanisms before then we start thinking about the US and London and Berlin and so on?
Okay. Yeah, again, let me start far and then come near. What was the name of this guy? The pedophile who died in jail the other day. The American one. Epstein.
Yeah.
Jeffrey Epstein. About 2 or 3 months ago, a group of American-based activists on behalf of victims filed a case against the banks that Epstein used to use for his businesses. And the court, I think it was in New York, issued a very huge fine to the banks, saying that if you did your KYC, your customers and so on, and if you took seriously your environmental, social, and governance requirements, you would not have aided and abetted and facilitated this man to do these businesses when the net effect of these businesses was this pedophilia. So a huge fine has been done against the banks. So for us, that's very important when we are expanding our thinking beyond what has been the narrow scope of our activism, or even the narrow scope of our public interest litigation, because we're just beginning in this area to do strategic litigation. A few cases here and there, like the tuna bond one is a really great success, where citizens said, can you open this thing? We want to know who gave our government loans, for what, where did that money go, what was the security used for it, and so on. And now it's going to end up, I think 1 or 2 ministers has been jailed, and the finance minister had for very long run away into South Africa and was resisting extradition. But I think the South African government in the last 2-3 months has agreed to extradite him. So he may or may not face the music back home, because it's still the same gang that's in power, So anyway, we can really think outside the box on how we can take this. One of the cases we're trying to work on now with a couple of other partners is Glencore. I don't know if anybody of you have heard about the Glencore scandal on the continent in the last 12 or so months. Glencore is a huge multinational that's in this extractive industry space, mining, oil and gas, and big deals. So it's one of the big multinationals. Its headquarters is in Switzerland. But of course, these big multinationals have subsidiaries all over. So sometimes it's like a hydra. You don't know which head is more important than the other, but they're all over. So now, the Americans, whose interest was protecting American companies, began investigating Glencore, which is not their company. It's a Swiss company. The reason they do these things, because Americans claim that, in some country, our company would have gotten the business, but it didn't because the other company bribed. So they've created all these extraterritorial laws where they can investigate other people for things that happened in third countries, because they can. You see, the way power is nice, you know? So they investigated Glencore and proved that Glencore was involved in serious bribery in 6 African countries and some Latin American countries. Brazil, Argentina, but here there was Cameroon, there was Nigeria, there was Equatorial Guinea, there was South Sudan, there was Central African Republic and DRC, you know, and so on. So because Glencore knew it was going to be jailed or is going to be convicted, they entered into a plea bargaining in the States, where they indeed confessed that yes, our guys did that. It was blatant. In some instances, they would like transfer money, wire money into their subsidiary in Nigeria. Like this one now, they're bribing Chantal Biya, the wife of the president in Cameroon. And then they just stuff this money into suitcase and they put it in a chartered flight and they fly it into Yaoundé and they take to the first lady, you know, and so on, you know, and others. You know, so then they paid a huge fine to the Americans. And then the Brits also caught them on the same thing, and they did plea bargain again to the Brits and paid a huge fine there. I mean, the money is huge. I'm not good in figures. You can look them up, or maybe Ranga can give them to you. The money is very huge in our thinking, but it's actually a week's turnover in Glencore's operations. So it's very, very big money. Any government would want to have a couple of $100 million for real. But how much does Glencore make on a daily basis? You know? So then some African countries went to ask, oh, so you give us this information, so you pursue because we're the real victims. Then those guys are like, actually, as part of the plea bargaining deal, we signed a non-disclosure agreement. That's what our American counterparts tell us. Because governments have mutual legal assistance amongst themselves, extradition agreements, cooperation, blah, 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 formal and informal. So the American taxpayer has been somewhat given some reparations for bribery in my country. The British taxpayer has been told sorry for bribery in my country. I get nothing. I don't even get the assistance to know which of my cousins is the one who was a receiver of the bribe and who are the enablers and blah, 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 so I can sort them out in the village, you know. So part of what we're doing as a group of activists that includes some lawyers, we're bringing on board some investigative journalists and so on, is to get enough information so that we can do some sort of legal gymnastics, legal and social gymnastics in our own countries. Again, the law is important, but it's not the most important. The most important is to get our public discussing these issues. And investigative journalists are better at finding this kind of information than even we are. So we're partnering with investigative journalists, sharing them what we know, asking them what they know, and hoping in their networks, because they do have networks, including continental networks and international networks, they find enough to begin naming people, like we did with the Panama Papers, the Paradise Papers, LuxLeaks, WikiLeaks, and so on. Name people, say, hey, your president's family have an account in Grenada or in Panama or who, and take it from there. But we're hoping to get enough information here where we can disrupt. Now, that now comes to the question you're asking, because sometimes there are simple things you can do even when there's a complex issue like this. So for instance, in countries where you can have a bit of a robust parliament, as many of our East African countries are, all you need is 1 or 2 champions, like these UPNIFT members, to at least go and ask the minister in parliament to come and disclose what the country knows and what the government is doing about this. Finance minister, foreign minister, attorney general, what are you doing about this scandal? So that's one of the things you can do. In other instances, a place to start is access to information laws, freedom of information laws where you have one. That at the very least you file an FOI request asking for more detailed information from your government. And even if it doesn't give you that whole rigmarole of going contesting with them that why isn't the public entitled to this information, could be a place to start. There are areas like, for instance, what our colleagues in Cameroon are doing, led by my former president, Akere Muna. They've gone to demand of the prosecutor. Because, you know, they have a devolved prosecution system. I don't understand it very well, but we've got different prosecutors in the Francophone civil law system. Some of them regional, so this province, that province, and so on. Some of them thematic, like working on specific issues. So he sent demands to 3 prosecutors coming from 3 different regions and said, from the information that's in the public domain, there should be enough for you to go on to investigate so we can find which of the individuals in this country were involved in this scandal and do something. So many times you start with that, and if then they write back to you and say, oh, I don't know, or oh, I don't have enough information, or F you, because they can do that also, you then go for mandamus. You go for an order and a judicial review saying you're not doing your job. So you try and get the courts to force them to do their job. And you tie them in these circles. In other countries, you can find that if you can get a name, then you even file a private criminal prosecution against that person, and tie them up in court. They might eventually be acquitted, either because you didn't have enough hard evidence. Obviously, corrupt people hide the evidence. They're not going to tell you, like, hey, Crystal, here's all you need to know how much I stole, Or the court was just not willing. The court was scared, or the court was compromised. But the entire process of trying to prosecute this person should amount to something. And as we say, the precedent we're learning from our American colleagues, if there's a way that you can go against some of the enablers, like the banks that moved the money, and stuff like that when you can. So again, is to think with a very open mind of the various things you can do. And again, in a lot of our countries, for instance, the National Human Rights Institution is also a quasi-judicial body. So you can go and file a complaint there. So you can file a complaint in court, but if your rights are implicated in any way, you can file a complaint before the National Human Rights Institution. And then there you're not even looking at the criminal law aspects. So the evidence, the burden of evidence that you need would be lower, because you need evidence just to prove a human rights violation, rather than the evidence to prove beyond reasonable doubt that a crime occurred. And you can find that one process can trigger you to get more information that can lead to another process. Get more information that can lead to another process. So you filing a human rights complaint and even naming people means they feel the urge, hey, let me go defend myself, Because they are filing the complaint against the government, not against individuals. But if you can name and shame, some of them may be like, if allegations are made against me in the tribunal, 5 years from now when I'm running for MP, I might be knocked out on ethical grounds. So let me go and try and defend myself. So in a sense, you're drawing them in. Is there a chance of losing? Yes. But at least you did something about it. Because if you didn't go to court, then nothing would happen anyway. So even if you lost, at least you've caused some action. So it's for us to also look at kind of a wide menu and then see what could apply when. Both in national courts, regional courts, continental courts, and so on. And one of the things we've discovered, like for us, especially for the litigation, strategic litigation, a whole range of issues, environmental, democracy, elections, various human rights that we've done, and now we're trying to do more of economic, social, and cultural rights. What we discovered is where you sue more than one entity together, like 2 or 3 government departments, or at the regional level, 2 or 3 governments. It's very nice because sometimes they cross-incriminate and incriminate each other. This one, in defending themselves, they're almost like, it's not me, it was so-and-so. Then the other one, like, no, actually, no, it's not me. You're also not saying that this happened. So many times, even when a case we filed was actually a fishing expedition, what happens is after that, the disclosures they have made themselves is enough to do the case. Yeah. So many times now, we just run the case on your evidence, man. You said, and I agreed, and so on. Yeah.
We've got about 5 minutes left.
Okay.
What?
I know.
Exactly.
Yeah. So again, just like Kanyisele and group did yesterday, we will then refine the PowerPoint and have something to send you to go home with. But as we said, the key elements are 1, disruption.
Could we also ask,
Yeah.
for example, or at least point us to the case examples that you explained?
Yeah.
So that we can
We'll give you complete with hyperlinks.
Okay.
It's good. We'll add the complete with hyperlinks on some of the best practices that we can rely on. So, again, borrowing from what your own session taught us, question the culture, question the patriarchy, question the so-called established, be irreverent about everything. Then also, be disruptive. So some things can be done in nice conventional ways, others are not. But we look at the architecture, the laws, and the institutions at these various levels. And there'll be some quick wins or some easily done things, but there'll be some also that I think are a bit more long-term, you know. So for instance, in our IFF space, I think 5 years ago, it was not, we would make those recommendations, making of international taxation rules should not be done by the OECD, it should be done at the UN, where each state at least nominally has one vote. But we used to say it, but it used to sound so pie in the sky.
Yeah.
Even we were saying it, it's like we didn't believe it. But in our lifetime, aided by a number of things, how we've networked, work we've done, because we must thank ourselves, you know, and other things that have happened, we're now staring at a place where there's a possibility that if we put the right push, then there can be a UN tax body in our lifetime. Even if it is neutered of some of the sharpest teeth it could have, but that we could actually have shifted the debate, or shifted the debate squarely into New York and squarely into within the UN. But that requires quite a bit of campaigning, quite a bit of advocacy, more than we're doing right now. So when we're thinking about how we want to deploy our time and how we want to expand the movement so that there's more hands doing the work, it's things like that in mind. Because if we don't make the investments now, the next 6 months, the next 12 months, we might not have enough of an opening to do something really meaningful. But disruption can be done. I don't know if there's anything else you want to add?
Yeah, I'll just speak to the issue of Glencoe. So me, I like reggae music a lot. There's a song by Joseph Yo. The song is called Payday. So in the song, he asks the slave master when their payday is going to be. So putting the issue of Glencoe into that context, when slave trade was abolished, it was the slave masters who were compensated. Now we have Glencoe, they've committed some crimes here on the continent, but then the issue is dealt with in America, and who gets compensated? It is the Americans, but it's not what us, you know, who lost a lot of money through their corruption. So just to add to what Don was saying, so we need to be disruptive and we need to be very, very innovative in terms of how we approach these issues. I think it's important to understand this history, like the conversation that we had in the morning. Slave trade, colonialism, neo-colonialism, etc. If we don't have that solid grounding on those issues, I think it becomes difficult, you know, to come up with proper solutions. We need that historical understanding so that we come with good solution to the problems that we are facing. Thanks.
Yes. Thanks.
Awesome. Before we I think Stefano, you okay.
Don,
Yes.
Just a quick one. You know, for me, it's like if I commit a crime and then in 3 or 4 years I commit another crime, almost similar to that, from a law perspective, that case gets remembered, isn't it?
Yeah.
Now, this is not the first time Lonmin does this. When 43 miners were shot at their backs in South Africa, it was Lonmin in the center of it. Like Lonmin argued, we can't give miners 12,500, which was already peanuts then. But the same Lonmin, for the same amount of work, rock drill operators in Australia, it was paying them at the time the salary of a middle manager for South Africa. So, and 43 miners died, and when they came to the Falan Commission, they actually did concede to the fact that, you know, it was unnecessary. But for Zulu's presentation tomorrow, in that period of 15 years, the platinum industry in South Africa was siphoning out at least a tune of 300 million rands of capital flight out of the country all the time. So meaning what they declared as profit was actually not profit. So it's not the first time that they are indicted for such things in Africa, but I'm sure when that case was heard in the US, this incident didn't even come up for this company.
It's quite possible it didn't. But that, I think, shows the importance of international cooperation and having networks with our friends all over. Because those are the kind of things, even when we're going for compensation here, we need to prove this company in other parts of the world, how has it treated this issue? And had there been a violation, either of a human's rights or of rules, what compensation have they paid, and so on, to make sure we get, more reasonable reparations for our people.
Your joke.
So, to end on a light note, because all this conversation about lawyers, and particularly corporate lawyers, of course. So here's the joke. So there's a commission that has a very complicated mandate. It needs to decide and select the first person to be sent to Mars. And of course, needs to decide about the compensation for this mission that, of course, has no return. So there you go. You have an engineer, a medical doctor, and a corporate lawyer. And let's say that they are all men, okay? Let me not add any gender dimension to this. So there comes the engineer, he meets in front of the commission, he was considered suitable for the role, and he needs to ask for the compensation. So the engineer says, well, of course, I need to think about my family, I will not be able to come back from this mission, so I want to ask $1 million for my family so that they can, of course, continue without me after I've left. Okay, the commission takes note. So there's come the medical doctor. Medical doctor comes in and say, well, I think I'm very, very good for the job, and I'm very pleased that the commission has shortlisted me. I'd like to ask $2 million. And the commission already, steps back and say, okay, what's going on here? Well, I need $1 million for my family, but I also need another $1 million to establish a foundation so that my name be remembered for what I've done for society. Okay. And there comes the corporate lawyer. He walks in, in a suit, very convinced, and say, I have it all clear. It's $3 million. And the commission, of course, takes a step back and say, $3 million? Yes, of course. Is one for me, one for you, and we send the engineer.